Hi, everyone. My name is Cooper Knowlton, and I'm joined today with Lee Bergstein. And we're going to be bringing you up to speed on a recent development that happened in New York City related to commercial leasing and personal guarantees. We know this is an issue that many people have been asking us about, and there was a recent decision in the commercial division in New York that may have important ramifications in the world of guarantees. So I'm gonna turn this over to Lee, and he's gonna provide us with a little background on the law at issue and the case, and we'll get into the nuances of the recent decision and what it might mean for commercial tenants in New York City.
Yeah, so just like a really quick reminder, we've talked about Administrative Code 22,005 before, which is a New York City Administrative Code provision that was enacted in May of 2020, kind of at the height of the pandemic. And the purpose of the code was really to protect a limited class of businesses, mostly restaurants, bars, retail establishments, and then personal care, barbershop, nail salons, things like that, from the personal liability of typically the principal who had signed a personal guarantee in connection with the lease. And the law basically said that if you defaulted as the tenant during the covered COVID period, which ended up running from March 2020 through June 2021. If you defaulted or there was some other event that gave rise to liability during that period, the personal guarantee, whether it was a good guy guarantee or a full guarantee, was rendered unenforceable. And that's been kind of challenged in a number of ways by landlords. Recently in November, it was challenged in the Southern District. The Southern District said it was enforceable, it wasn't unconstitutional. But now the cases are being litigated in New York State Court, and there was this recent decision in July by Judge Leibovitz, which I think is really important, really notable. Cooper, you want to talk about the facts of that case really quickly?
Sure. Yeah. I mean, the fact pattern is fairly straightforward. We're talking about a restaurant that in the middle of COVID was forced to shut down. And in June of last year, June of 2020, they notified the landlord that they were going to be vacating the space, that they were shutting down. A few weeks later, mailed in the keys and actually did vacate. The landlord promptly commenced litigation for all the unpaid rent, the utilities, water, sewage, basically, all the unpaid amounts. The lease was through 2027. So obviously there was 7 years still remaining on the lease, and there was a good guy clause that was litigated over, but really the relevant provision was that the defendant, in this case the restaurant, pointed to for the individuals who were personally guaranteeing this restaurant lease, invoked when they were sued, they invoked this administrative code that Lee previously discussed, and essentially said that we're not on the hook because of this new piece of legislation that was passed by the city council, right?
Yep.
Yeah. And so, do you want to explain what the ruling was?
Sure. So the landlord basically threw the kitchen sink in terms of arguments at the court. They argued that it wasn't constitutional. They argued that because the guarantee was a separate document from the lease, that it shouldn't have been enforceable. They made arguments with respect to retroactivity. The court kind of brushed all those arguments to the side. And then ultimately they said that it just doesn't apply to the full life of the lease. The guarantor is on the hook. And this has been kind of an open question, whether courts were going to rule that the guarantee was just non-enforceable for that really limited period, for that 1 year period, or whether it was going to be rendered unenforceable for the life of the lease. And this court basically took the latter. They said because of the administrative code law, because of the fact that the restaurant defaulted during the COVID period, they actually defaulted in June or July of 2020, that they're no longer liable for any of their lease obligations. They were actually, the court found that they were liable for a very limited set of money, unrelated to rent payments. But
It
other
was
than that,
previous stuff though, right? It was stuff that was in the past that they weren't liable for. So unpaid, they couldn't get out of amounts that were previously owed, but everything moving forward, they were able to get out of.
that's right, right. So this is obviously really notable for restaurants, bars, retail establishments, and other covered businesses that defaulted or were involved in some event that gave rise to liability during the COVID period. Because this court, at least, and again, this is one trial court out of many trial courts, has decided if you're a covered business and you defaulted during that covered period and there's a personal guarantee, that guarantee is not enforceable. A couple of things that we should probably note. This is a very specific factual situation. This tenant actually vacated during the COVID period. A lot of tenants obviously weren't sure what was going to happen. They were negotiating with their landlord. They're still there, or they didn't leave during the COVID period. There could be a distinction with respect to that if the tenant stayed in the space. And then the other piece is obviously this is a restaurant, right? So very clearly fits within the law. There are a number of other businesses that maybe you could call them retail, maybe you don't call them retail. Maybe they're in some way more closely aligned to a personal care type of business, like a barber shop or nail salon, but the landlord would make the opposite argument. So there are a number of distinctions possible out there, but for this particular type of factual situation, a pretty good ruling for tenants amidst a sea of somewhat bad rulings for tenants over the course of the last 6 to 8 months.
Yeah. Yeah, it's going to be interesting to see how this, continues to be interpreted. Is in your mind the main open question is still, there was a good guy guarantee, right, in this particular case. So the liability was in all likelihood going to be limited to the 6-month good guy guarantee clause in this lease. But if that extended beyond the covered period, how do you think this would shake out?
You mean if the good guy protection extended beyond the covered period?
I guess if the good guy period had not extended beyond the covered period, right? If there was a lapse, if there was a month or two lapse at the end.
Yeah, I think the way at least this court interpreted this is this applies to any type of guarantee as long as the default or event that gave rise to liability, and that phrase is going to be litigated because there were tenants who didn't default but who stopped paying rent or just they couldn't pay rent, and now landlords, after the covered period is over, now landlords are serving them with notices of default, going to court and instituting proceedings, suing both the tenant and the guarantor. Is that going to make a difference because your actual event of default didn't happen during the covered period? So it'll be interesting to see. But if you were a tenant and you left and you're one of these covered businesses, this is a pretty good ruling for you. Interesting to note before we go that even though the court gave a tenant-friendly ruling here, they still said with respect to frustration of purpose and impossibility, those are not very good arguments. The restaurant was able to do takeout and curbside pickup, so they weren't totally prevented from doing business, and that's kind of aligned with how a lot of trial courts have ruled with respect to those arguments. There have been a few arguments that were tenant-friendly, but they've been far and few between.
Yeah, and I think the last thing is also, we briefly touched on this, but if a restaurant was already $1 million underwater pre-pandemic, it's unlikely that this is going to protect them for that $1 million. It might protect them for everything moving forward on the lease, but it's unlikely to be sort of a perfect solution for getting out of personal guarantees. Yeah,
I mean, it's not going to forgive what you owed as tenant or guarantor prior to the onset of the COVID period. The interesting thing is, though, we weren't sure whether tenants that were in arrears prior to COVID, whether they would be able to benefit from this provision at all, because
Right.
The landlord could argue the event of default occurred prior to COVID. But here, that's the court didn't. The landlord doesn't appear to have argued that at all here, and the court didn't step in and say that was the case. So it's possible that will be an argument moving forward, but the court didn't really seem to finds an issue. They basically said the arrears due prior to COVID, you owe. Everything after, you don't.
Yeah. All right. Well, I think that's a pretty good summary. I think good place to stop.
Pretty good place to stop. It's a good guy place to stop.
All right. Well, as always, if you have any questions about this or any other topic, please feel free to reach out. Yeah, thanks